Good morning and welcome to another edition of the Waterstone Legal Update. I'm William van Roosmalen and with me is Damien Grant, liquidator.
Fashion icon, William van Roosmalen.
And not so fashion icon, Damien.
Oh my God.
This morning we're talking about peace and glory.
What a great name. I think that's one of the reasons why this case has resonated, just the name.
So this is a relatively old case dating back to 2009, the Court of Appeal judgment.
For me, it's not such an old case because I was born in 1966. You were born in 2004. So for you, it's an old case.
94.
Don't correct me.
So Damien, why don't you take us through the facts and the High Court judgment?
All right. Look, I really enjoy this case. So it was Mr Samsa, I think you pronounce his name. He was an immigrant to New Zealand. He was a qualified architect, and as in the way with many new migrants to New Zealand, he got into property development, which makes sense because he was an architect. So in 2002, he buys his property at 37 Alton Ave in Northcote, and he purchases it for $350,000, and he buys it partly with money from his mother, and there was a little bit about an argument about that because he borrowed the money from his mother, and then he subsequently transferred that loan into the name of the company Peace and Glory. So when the loan was originally done, Peace and Glory didn't exist. Nothing turned on that in the end, but that was one of the things that was argued about in the High Court. He also got a loan from the ASB Bank, and he tipped in $140,000 of his own money. Now, the reason why he did this was property development. So he then spent $120,000 on the property to try and get it up to spec and sell it and make a profit. So he spent the $120,000, and then he had the Inland Revenue Department chasing him for about $45,000 in GST. There was some back and forth. He attempted to compromise that debt down to $30,000. The Inland Revenue Department wouldn't do a deal. He then tried to sell the property, got a valuation of $357,000, which was less than the debts that existed at the time. He then sold the business to himself for $395,000. And then the Inland Revenue Department subsequently liquidated the company and put Deloitte and Mr Levin in. Mr Levin then challenged the director, Mr Samsa, and said, okay, you've done a couple of things. You breached your duties as a director, so you didn't act in good faith and incurred obligations and a few other bits and pieces.
That being the GST obligation on the sale of the property.
So Levin was making the argument that, well, hold on, by doing what he did, by selling it to himself, he was choosing which creditors got paid and which creditors didn't get paid. Kind of similar to what we saw in the argument in Dayberry Homes, actually. So that was the argument that Mr Levin was making. Mr Levin said what the director should have done is he should have gone to the mortgagee, the ASB Bank or whoever, and got them to sell it, because then the GST potentially would have been paid, but then the secured creditor wouldn't. Alternatively, he could have put the company into liquidation. He also made the argument that the failure to keep proper accounting records under Section 194 was a breach. Now, the rule under Section 194, failure to keep proper accounting records, that can become a problem for a director if the failure to keep those proper accounting records results in the liquidation or hinders the recoveries in a liquidation. Now, Mr Levin was unsuccessful, and he was unsuccessful for a couple of reasons. The first is the court looked at what did the director, Mr Samsa, do. The High Court went back and looked at some previous decisions and said, look, High Court judges are reluctant to micromanage decisions made by directors. Directors will have a presumption that they are acting in good faith under Section 131.
And I think we agree with that.
I would agree with that. It's very easy to sit in ivory towers and criticise other people, and the courts are very mindful that that's exactly what they're doing. So they're quite reluctant to second guess the director. The High Court said Mr Samsa made the best of bad options in front of him. So this is particularly relevant for the 136, 135 claims. So the court said, okay, spending the $120,000 to develop the property was probably, in hindsight, a mistake. When the director was sitting there looking at what his options were, whatever decision he made, there was going to be creditors that were going to be unpaid. So he made the decision to sell the business to himself. Under 136, which we spoke about in the Whatapato and Bates case, there's a subjective and an objective element to it. Did this director believe that the decision he was making was going to result in was the correct decision to make, and did he have an objective reason to believe that? Would a rational person, a reasonable person in the director's position believe that? And the court said yes to both of those. So on both of those situations, the court found that he hadn't breached his duties or not. Then we came to section 194. So here the court says, yes, Mr. Director, you almost certainly failed to keep proper accounting records. But they said that the company director had enough information in his head that he knew where the company was at. He at a high level, he knew what the numbers were. So in order to breach the corporate veil and hold a director personally liable for the debts of the company, a liquidator must first prove that the company director breached their duties, and Mr. Levin failed to do that for the 131, 136, 135 elements. But in the second part of that test is first you show that the director breached the duties, then under 301 the court can then adjudicate an appropriate consequence. And on 194, the High Court seemed to indicate, well, yes, Mr. Director, you didn't keep proper accounting records, but there was no material impact on the insolvency of the business as a consequence of that. The liquidator wasn't unnecessarily harmed, neither were the creditors. You didn't keep proper accounting records, but ultimately nothing turned on that. And so they declined to make an order against the director. So that's what happened at the High Court. Mr. Levin, tenacious liquidator that he is, and we like tenacious liquidators at Waterstone, took it to the Court of Appeal, and what happened there?
Well, in summary, he lost, and the Court of Appeal basically said they analysed the High Court's reasoning, and they said we accept that the judge in the first instance didn't apply the correct express two-stage test, whether or not the director breached his duty, and then what amount is or should be payable under section 301, took submissions, and the liquidators said the trial judge did it in a roundabout way, and the Court of Appeal effectively said that he impliedly did that two-stage test by saying that Mr Samsa was taking the least unattractive option in the circumstances. They said a number of things about the different sale options, whether it was a invited mortgagee sale or the different options, sell it to himself as he eventually did. There were different ways in which the debts would fall depending on which option you take. So if it was an invited mortgagee sale, then the secured creditor would potentially get paid out in a different priority than if a different option was taken. They said in terms of the proper accounting records that there was no causative effect on the insolvency of the company. It was a small company, it didn't have a lot of going in, going out, roundabout ways what was going on, and also the IRD had a lot of information as well. So the liquidators didn't approach the IRD for those records, and so Mr Samsa couldn't reasonably be held to account for a breach under section 134.
You've got something highlighted.
Yes, there were a few interesting things that the Court of Appeal say. They note that the IRD wrote to Mr Samsa in 2003 saying that they were effectively requiring the property to be put on the market, and that was despite them being told that there would be a GST shortfall. That was a letter that Mr Samsa wrote to the IRD, and so they said that diminished his liability quite considerably because the IRD was...
Because the IRD was informed.
They were informed, and they were effectively going along with it. So at the end of the day, it gives us some clarity. I think that the case gives us some clarity about the treatment of GST on property sales. Debut Homes changed it somewhat because they said you can't pick and choose your creditors.
Yeah, but I don't know that this was necessarily an analogous situation to Debut Homes. I mean, Debut Homes, you had different creditors effectively getting paid as a result of what the directors there were making a decision to continue to trade, favoured one over the other. In this situation, it didn't really matter what Mr Samsa did. Somebody was going to get unpaid. But it would be interesting to know looking at this, I think if you looked at this case through a debut homes lens, you could run an argument that on this one, Mr Levin would potentially have prevailed, because looking at the debut analysis, says, he was potentially robbing Peter to pay Paul, because what he was doing was he was saying, okay, I'm going to buy it. He then claimed GST in the new company, or in his own name, I think, clipped $39,000 worth of GST on the sale, because GST was 10% back then. And as a result of that, of course, he left the Inland Revenue Department behind in peace and glory, and so they were a creditor, obviously they liquidated. So it would be interesting if this case was run again, looking at it through a debut homes lens, Mr Levin might have prevailed. And he was a liquidator on debut homes, wasn't he? I think he was.
Possibly.
Maybe debut homes was Levin's revenge. So I think that's all for us. Peace and glory. So we've been doing a couple of old cases, but I think it's good to do some of the old cases.
Well, and also we did do debut homes.
We did do debut homes, but we did Whatapato and Bates. But some of these old cases still resonate, and some of those cases still coming through. So I think it's quite important from an insolvency perspective to go back and remind ourselves of some of these cases, because some of the stuff still stands.
And stay tuned for our analysis of Mainzeal. It's
coming
in the pipeline.
It's coming. It's a big case. All right. Thank you so much for watching. For those of you who get to the end, a surprising number of people actually get all the way to the end of these. You think it'd be 10 or 15, but it's in the hundreds, which is very satisfying.
Yeah.
All right. And if you want to get in touch with us, our contact details will be down below. Thanks for watching.
Cheers.